Welcome to the webinar. We'll begin shortly. Thank you for joining us. Welcome to the webinar. We'll begin in a few moments. Welcome to the webinar. Thank you for joining us. We will begin shortly. Hello, and welcome to our webinar, Estate Planning for Today. My name is Brian Powers, and I'm the Vice President for Marketing and Business Development with JGS CPA. We're happy to have you here. Our speakers for today's webinar are Michael Wagner, Senior Counsel at Jacobowitz and Gubits. Michael concentrates in estate planning, elder law, guardianships, wills, and trusts. And today we'll discuss estate planning, probate, and Medicaid asset protection. Michael is joined by Bonnie Orr, partner here at JGS CPA. Bonnie works closely with our clients and their attorneys, providing estate and personal tax planning strategies to maximize the transfer of wealth to future generations, all while providing for a comfortable retirement. Bonnie will provide an overview of the current environment of estate taxes and how your estate plan decisions impact your tax planning. Before I turn it over to Michael and Bonnie, I'd like to let you know that this portion of the webinar is pre-recorded. But at the end of the webinar, please stay around. We'll come back on live to answer questions. But at any time you have a question during the webinar, we'll also be answering them through the chat feature. Please feel free to enter them in the chat at any time during our webinar. And we look forward to seeing you at the end for a live Q&A session. And now I'd like to turn the presentation over to Michael Wagner of Jacobowitz and Gubits. Michael?
Okay, thank you again for watching, everyone. Once again, my name is Mike Wagner with Jacobowitz and Gubits. We're talking today about wills and trusts and estate planning. So let's jump right in. When someone dies with a will, it's a pretty familiar circumstance. You've probably seen it in the movies and on TV. Usually less dramatic. Usually there's no reading of the will under such formal circumstances, but it does go through a process called probate. And I'm not here to tell you today that that's the end of the world and that nobody should have a probate proceeding. But for some people, it might be worth looking at alternatives. Probate is a process in the county surrogate's court where the executor of the will goes to get formally appointed in the role. So essentially, the executor is not authorized to act until he or she gets letters testamentary from the court. So if there's taxes to be paid, if there's beneficiaries who are anxiously awaiting their inheritance, if there's a property to sell, everything is kind of in a holding pattern until the executor is formally appointed in the role. They are nominated by the court, by the will, but they are appointed formally by the court. So important to note that probate takes some time. Now, in a family where everyone gets along or that where everything is fairly straightforward, a probate is not going to be a terrible process. So in some families, it is not something that you need to be concerned about. But it also costs money. When someone dies with a will and an attorney is hired to do the probate, whether it's a flat fee or an hourly fee or some other legal fee, it is going to be significant. So it is oftentimes worth looking at alternatives to probate to save time and money and legal fees. The time that probate takes can vary greatly. It could be anywhere from a couple of weeks under the best circumstances where the volume at the court is light and there's no problems with the filing to months and months. And if people are going to contest and litigate, then even sometimes years. So when we talk about alternatives to wills, we talk about trusts. So when people ask me what's the difference between a will and a trust, it basically works like this. A will is a set of instructions for death. A will states that at the time I pass away, my assets will go to the various beneficiaries. But a trust can do a lot more. A trust is really a plan for right now while you're healthy and well. Later, in the event you become sick or homebound or disabled and you can't manage your own affairs. And also, a trust seamlessly transitions into a plan for death. So, whereas a will takes effect when you pass away, a trust is active right now as soon as you make it. A key difference between a will and a trust is that a trust needs to get funded. A trust is like creating an entity, sort of like a company for yourself. And it's not enough just to make the trust and write it out on paper. You actually have to fund the trust, which means you have to transfer your assets, retitle them into the name of the trust. And the law firm would help with that. So if you've got deeds to real property, we would transfer those into the name of the trust. Bank and brokerage accounts, we would work with you, your accountant, your financial advisor to sort of make a plan for what goes into the trust and why and how. So basically, whereas a will, you just write out your instructions and they get looked at when you pass away, a trust is an active estate plan that gets funded when you make it and reviewed regularly and managed more like a company than a will, which is just like a set of instructions. So trusts have that different trajectory, but trusts can do a lot more. When someone passes away, a trust does not go through probate. The trustee who's acting at that time is entitled to sell the property and pay out the bequest to the beneficiaries, pay the taxes, handle whatever business needs to be done. So on death, trust can be handled a lot easier and more efficiently than wills can. Another key difference is that wills are public record. When someone dies with a will and it goes to the county surrogate's court, it can be accessed. If you wonder how celebrities' wills get on the internet, it's because eventually they do become public record. With trusts, they are private proceedings. Trusts are not public record. Only the people who are directly involved with the trust really are entitled to have a copy of the trust document. So those are more private. So typically, the advantage of trusts saves time because we're not waiting on a court proceeding, saves money in legal fees usually, and also can ensure privacy for your family. Again, a trust is not for everyone in every situation. What we do is we look and we evaluate someone's situation, their needs, their wants, what their objectives are with regard to estate planning, and we make the recommendation of whether they should have a trust or a will-based estate plan. So that's really the key difference between a trust and a will is how they're written, how they function, how they're administered. One involves going to court, and the other does not. If you have property in multiple states, you may look at doing a trust because it can avoid probate not just in New York, but anywhere else where you might own assets. You could deed those properties to the trust and avoid ancillary proceedings in those states as well. So it has that advantage. If you're concerned that someone might contest your wishes, that your family might litigate, a trust is as secure as you can get with your estate plan. Certainly anyone can fight over anything in court, but trusts are as secure as you can get with an estate plan. So there are certainly options to discuss with your estate planning attorney if you're concerned that the people in your family might fight and dispute what your wishes are. Another reason to make a trust. Something else you can do with trusts is bloodline planning. So when someone dies, the estate plan often says, I give it to my son or to my daughter per stirpes. Per stirpes means through the bloodline. So basically, if someone predeceases you, your son or daughter dies before you, it would go through the bloodline to the grandchildren or whomever is next in the family. And usually that's legally adopted children or blood children, but not stepchildren. So legally adopted or blood count under per stirpes, but not stepchildren. So that's standard language. But some people want to go beyond that because most of the time, fortunately, your children do not predecease you. They live for many years after you. They post-decease you. And some people want to have some level of say in what those heirs do with the inheritance. Because the concern is, what if they're really young? Or what if they're just going to blow it because they're not responsible? You know, they say if you leave your 18-year-old $500,000, he or she's not going to have it when they're 19 years old, right? So we put age restrictions on inheritances in trusts. We say, yes, a young person can inherit money. Yes, it's protected in all the ways that that we can protect it. We can insulate it with the right trust planning from creditors, from lawsuits, from divorces. But basically, we also say that there's an age. Maybe it's 25, maybe it's 30 or 35, maybe it's a staggered distribution scheme. But ultimately, the beneficiary will get their money. If they're younger, college age or so, it's managed by a trustee who could be a family member, could be a professional. And the fact is, the trustee has the say over whether they need money for their education or for a car or something else. The trustee could make a disbursement for that. Or the trustee could say, you know what, not mature enough, not worth it, we're holding it in trust until they reach the stated age. So the trustee has that broad discretion, or narrow discretion if you want to make it specific. But basically, you can hold it in trust until they're a certain age. Sometimes it has nothing to do with how old or how young a beneficiary is, though. It may be that they're irresponsible with money. Gambling, drugs, alcohol, they don't have a job and they don't understand the value of money. There just may be some reason why it's not a good idea to give a beneficiary unlimited access to the inheritance. And if that's the case, there are lots of ways that trusts could be written and tweaked so that beneficiaries have access to the money and have access to it in a way where it will stretch across their lifetime, or at least a very, very long time, and they're not going to blow it right after you pass away. So if you've got beneficiaries who may have shopping or spending problems or just issues with money, it's worth talking about custom tailoring the trust just to meet their needs. Because the fact is, the trust doesn't just protect money for the beneficiaries, it can protect money from the beneficiaries as well to make sure it really does last. And as I stated just a minute ago, you can also make trusts for your beneficiaries if you want to go this far that will insulate it from their creditors, lawsuits, divorces, and make sure on death it goes through the bloodline to children or grandchildren and doesn't go to spouses and in-laws and people who maybe you do not feel should get the money. So you can do a lot with trusts in the way of bloodline planning. You can really insulate the inheritance, make sure it lasts a lifetime, and state where it goes on the death of the beneficiary. Again, some people just say, hey, I'll be gone, let them do with it what they'd like, but others really do want some level of say in what happens to the inheritance long after they're gone, and that is doable. If you draft your trust the right way, you could ensure that the money is going to be used for a safe, secure, and valuable purpose in the long run. So you can make a trust for the benefit of your children or grandchildren that would insulate and protect the inheritance and make sure it stays in the bloodline and doesn't really go to in-laws or others who you might not want to get the money. Similarly with second marriages, if you have a situation where, the Mike and Carol Brady situation where one spouse has kids from a prior marriage and so does the other, and now everybody's an adult, you can use trusts to make sure that it doesn't create this morbid dynamic of who dies first and who's the survivor and what are they going to do with the money. You could make trusts to ensure that the money stays in the family and is doled out proportionately regardless of which spouse dies first, so that the children of both spouses can inherit proportionately and appropriately as planned, and it doesn't make any difference who the first to pass away is. So if a second marriage is a concern, that's something we see a lot of and we deal with when it comes to estate planning. Very quickly, I want to mention Medicaid asset protection. We could give a talk on this, and we do, and you're welcome to attend more webinars, but we could go on about this for an hour. But Medicaid asset protection is another key feature of trusts. Some people want trusts not just to avoid probate, but to make sure that the inheritance stays protected from long-term care and nursing home costs, so it doesn't get lost before people pass away. Because nursing homes often cost $150,000, $200,000 a year now. So the cost of that could wipe out life savings. And the concern is, how do we protect assets in the absence of, the ability to pay that, or the long-term care insurance policy to pay that fee? How do we protect assets from the nursing home? And there are ways that you can create trusts in advance so that the assets are insulated and protected. What I'll say is the trust must be irrevocable with an I, irrevocable, which means not exactly that you can never change it or cancel it, but it does mean that it's a little bit more restrictive than the standard revocable trust. The irrevocable trust does have some rules to it, certainly which we'd have to talk about at greater length. And you also need to start 5 years in advance, right? You need to start, be cognizant of the 60-month look-back period, 5 years, and do the trust 5 years before you need nursing home care. Nobody can predict the future. Nobody knows exactly when they might need long-term care. But doing the trust in your 60s or 70s is a really good bet. I want to just mention that there's never a wrong time to consult an elder law attorney. Even if you know someone who's on the nursing home doorstep, so to speak, there are still strategies that we can use to protect assets at the last moment. So Medicaid asset protection is a whole other webinar topic, but just to give you a taste of that, trusts can be used up to 5 years in advance to protect assets from the nursing home. If it's a short-term thing and someone needs a nursing home immediately, there are other strategies we can use. That's about all the time I have for today, but I do want to mention that Jacobowitz and Gubits offers free consultations. We'd be happy to meet with you. We'd be happy to discuss estate planning. We do consultations at our office and on Zoom. And other video chat and on the phone. So basically, we'd be happy to meet with you, go over your estate plan currently. If you have one, we'll review any will or trust that you have currently, power of attorney, healthcare proxy, whatever estate planning documents you have, bring them in. I'd be happy to take a look at them, go over them, and make some recommendations. It's not a hard sell. If we think something is working for you and the plan makes sense, we're going to advise you to keep it in place. But if there's recommendations for you that could make things better when it comes to probate or long-term care and nursing home cost planning or estate tax planning, we can certainly make those recommendations. The consultations are free without any sort of obligation. We go through the key questions with you for estate planning, analyze, make recommendations, quote a legal fee. We do follow-up consultations as needed. There's never any obligation. When you're ready, we move forward to a signing of the estate plan, and we really go through it with you in great detail and translate the legalese into English, make sure you feel totally comfortable with the estate plan, and then we sign. But the relationship doesn't end there. We contact you at least every 4 years, if you don't contact us earlier, to review your estate plan, make sure it's accurate, up to date, and reflective of your wishes. We don't want it to be something you put in a drawer and never think about again. We want it to be something that you actively review and think about and talk about with us, just to go over if there's been changes in the law, changes in your life, and anything that needs to be updated. So that relationship really does last. That's the value of our service, is that we monitor and maintain those estate plans. I want to thank everybody out there for watching. It's been great talking to you. And now, for more on the tax side of things, I'm going to turn it over to Bonnie Orr.
Hello, everyone. Thank you for attending our webinar. A special thank you to Michael Wagner for his presentation on estates and trusts, and to our marketing gurus, Brian Powers and Valerie Gross, for making this presentation possible with their technology expertise. My name is Bonnie Orr. I am a CPA partner with the firm of JGS CPA. My field of interest is taxation, especially business taxation and the related taxation of business owners. In addition, I have developed a specialty niche in estate and trust taxation. I work with clients and their attorneys to help develop estate and trust plans that accomplish their goals for passing assets to their heirs, while also providing what they need to enjoy their retirement plans. This often includes succession planning for business owners. We plan for tax-efficient ways to pass assets to their heirs. One thing I have learned through the years is that estate plans are as individual as the people who we do this for. Everyone is unique, and there are usually special circumstances that must be planned for to properly assist our clients. Still, there are certain core items to be aware of as one creates their estate plan. Today, I will address some of the more important items to be aware of as you consider your own individual estate planning. Please do be aware that we are discussing estate tax issues in the context of the law as it is in place today, January 2021. As always, we expect the laws to change over time. It has been my experience, however, that a properly drafted will or trust will include wording that provides for changes in estate and trust tax law, in effect, keeping the plan tax efficient. So let's get started with a discussion of the federal estate tax exemption. For those of you who are wondering what the federal estate exemption is, I will explain. There is a federal estate tax. The tax rate is 40% on the value of our taxable estate if our taxable estate exceeds a certain amount. Currently, that amount is $11,700,000. This means that if you die leaving an estate valued at, say, $12,700,000, your heirs will pay a 40% estate tax on the $1 million excess over $11,700,000. That tax would be $400,000. Now, if you expect your assets to be under the $11,700,000 when you die, and if you do not think the federal government will lower this exemption amount, then you do not need to be concerned about the estate tax. Income taxes and the step-up should be your concern. If you are married and your assets are over the $11,700,000, well, you might be interested in the portability rule. Under current federal law, a married couple gets to use both exemptions for a total of $23,400,000 in estate that will not be taxed. This is called portability, and we get this by timely filing a federal estate tax return called a Form 706 when the first spouse passes away. We generally recommend that surviving spouses timely file estate tax returns when the first spouse passes away, even if their assets are substantially under $23 million. This is to preserve an additional estate tax exemption amount for the survivor. It is a protective measure. If the estate tax exemption is lower when the second spouse dies, and if the portability amount is grandfathered, well, then the second to die will be able to use a higher exemption amount. Portability is a federal estate tax savings device. Most states do not allow portability to apply to their state, estate, or inheritance tax. Note that some states, such as Florida, do not impose estate and inheritance taxes, but many do. One should always consider their resident state tax laws in their tax planning. Also, consider the tax laws of any state in which you operate a business or own real estate. For New York State residents, be aware that New York State taxes an estate with assets over $5,930,000 in 2021, and the New York estate tax rate is 5 to 16%. However, the New York estate tax calculation includes an issue that we call the cliff. If a New York taxable estate is just a bit higher than the exemption amount, say 5% higher, the New York estate tax bracket is very high. For example, a New York taxable estate of $6,226,000 in 2021 will incur a New York estate tax of about $500,000. Interestingly, a $300,000 charitable bequest, reducing the taxable estate to $5,926,000, will reduce the New York estate tax to zero. Yes, you heard me right. A $300,000 bequest to charity could save $500,000 in New York estate tax. Some attorneys are including conditional charitable bequests in wills and trusts to provide that your charity of choice will receive an amount that is less than the New York estate tax would be if there were no charitable deduction. As I throw out these numbers, 11,700,000 federal exemption, 5,930,000 New York exemption, you might be wondering, what is includable in a taxable estate? While the answer is fairly technical, a good rule of thumb is that your taxable estate includes the value of everything you possessed and controlled the use of at the date of your death, reduced by your debt and certain costs of administering your estate. Many people are surprised to learn that our taxable estate includes assets that do not go through probate, such as an IRA and employer retirement accounts, real estate, even if it is owned jointly with another person. Bank and investment accounts, even if they are owned jointly or set up to avoid probate with transfer on death instructions. And life insurance is if it is not owned by a properly maintained life insurance trust. Our business assets are often the most difficult to do proper estate planning for. I say this because most businesses are worth quite a bit, but do not have ready cash to cover estate taxes. Business assets are usually tied up in inventory, accounts receivable, goodwill, and real estate. Business owner estate planning requires extra care to ensure that the business will succeed when we are no longer around. Buy-sell agreements and plans for funding the transfer of a business are critical to a business owner's estate plan. There are ways to reduce the estate tax, and with proper planning, most people can get their estate tax down to zero or close to it. When appropriate, we encourage lifetime gifting to reduce estate taxes. Some of the most commonly used strategies are gifting $15,000 per year to as many people as you wish, paying the tuition and medical expenses of your heirs, gifting to irrevocable life insurance trusts to keep life insurance out of your estate. Now, if you do this, do not forget the crummy letters. And for large estates, it often makes sense to gift more than the $15,000 per person per year to get the future appreciation out of that large estate. There is a gift tax and we are required to report lifetime gifts that exceed the $15,000 per person amount. Lifetime taxable gifts in excess of the $11,700,000 exemption are subject to a 40% gift tax. A current large estate strategy is to gift $11 million now, anticipating that the exemption will be lowered under future administrations. We expect, but of course can never be certain, that any change in estate tax law will include provisions grandfathering prior transfers so that they do not become taxable. This is a good time for me to point out that gifts during our lifetime carry our cost basis to the person receiving them. There is no step-up applied to lifetime gifts of appreciated assets. Let me try to explain this. In addition to the estate tax issues, we must consider income taxes. Current income tax law includes a very special provision we call the step-up. Certain assets that we leave to our heirs get their cost basis reset to their market value when we pass. This is most powerful when applied to rental properties, which are often fully depreciated during our lives. Heirs inheriting the family rental property portfolio get to start depreciation all over again. Or they can sell the properties immediately after inheriting them and pay little or no capital gains tax. This also applies to a stock portfolio as long as it is not part of an IRA. IRA accounts, tax-deferred annuities, and installment sales are assets that do not get the step-up advantage when we pass away. As the accountant familiar with our clients' income tax issues, we look to preserve the step-up whenever possible. Trusts are often a very important part of an estate plan. As Michael pointed out, they are used to avoid probate, providing heirs with an efficient way to transfer assets. Trusts are vital for asset protection planning and for controlling the use of our assets when we are no longer able. There are many different types of trusts, and not surprisingly, different types of trusts have different types of tax treatment. Revocable living trusts are most flexible because we can change them. They are revocable during our lifetime. IRS considers assets held by a revocable living trust to be taxed as if they are still owned by the grantor. The grantor, by the way, is the person who creates and funds the trust. Revocable living trust assets are part of our taxable estate. Revocable living trusts do avoid probate, and if applicable, there is a step up for the heirs. Irrevocable trusts are trickier. To determine estate and income tax consequences, we must examine the trust document provisions. For example, an irrevocable grantor trust that provides the grantor with income for life but no principal will be included in the taxable estate, and the step-up may also be preserved. The grantor, again, that's the person creating and funding the trust, will continue to pay income taxes on the trust income during their lifetime. Irrevocable trusts that do not pay income back to the grantor may have to pay their own income taxes. Currently, income tax rates for trusts are fairly high. If the goal is to preserve trust assets for heirs, it might be best for the grantor to continue to pay the income taxes on the trust income. This can be accomplished by giving the grantor certain powers. A commonly used power to get income taxation back to the grantor is the power to substitute assets of equal value. We examine the distribution rules of trust created upon death. We look for flexibility to pass the income tax liability to beneficiaries who might have lower tax brackets than the trust itself, such as perhaps the grandchildren. By now, I hope you realize that income tax planning is a big part of estate tax planning. Income tax planning should be multi-generational, and we as tax planners are often asked for the best ways to gift to children and grandchildren. A 529 plan is a great way to gift to grandchildren. Income earned in the plan is never taxed if they use it for tuition and qualifying fees. And if they don't, well, they can transfer the 529 to a qualifying relative who will use it for education. Roth IRA accounts are extremely valuable because they are never subject to income taxes if held for 5 years and to age 59 and a half. Help your children and grandchildren fund their own Roth accounts. If they are young, the power of compounding is on their side. Did you know that $5,000 invested today and left to grow for 40 years at a compounded rate of 7% will exceed $80,000 at the end of 40 years? I like to tell my 20-year-old clients that their $5,000 contribution to a Roth could fund much of their first year of retirement at age 60. And consider rolling your own traditional IRA to a Roth. Personal income tax rates are still at an all-time low. Then let your Roth grow tax-free for as long as possible. Roth IRA accounts are not subject to any required minimum distribution rules during the original owner's life. Roth IRA accounts, just like traditional IRA accounts, must be paid out within 10 years of death when inherited. The big difference between an inherited Roth and an inherited traditional IRA is that the beneficiary will not pay income taxes on the Roth. They may pay income taxes on the traditional IRA. Most people are in 20 to 40% income tax brackets, depending upon their other income. This makes a traditional IRA worth less due to the income tax liability that it carries. Sometimes we are asked, is it a good idea to gift the residence to adult children? While the answer is, it depends, the tax consequence is easily explained. If the residence is sold later by children who did not live there long enough to qualify for special sale of residence tax breaks, then the children will pay capital gains tax on the difference between the parents' cost basis and the sale price. If instead the children inherit the residence from mom and dad, or inherit it from a grantor trust that was created by mom and dad, then there is a step up at the time of the parent's death, so that the capital gains tax is on the difference between the value at parent's death and the sale price. In this case, the step up could prove to be a valuable estate and income tax planning tool. So far, I have talked about gifting to heirs, but have not paid much attention to the use of charitable gifting in an estate plan. People often include their favorite charitable causes in their estate plans, and for those of you who do, here are a few items of advice. If possible, name your charity as beneficiary of part or all of any traditional IRA or taxable 401k or 403b. The charity will not pay income taxes on those retirement accounts, but your children or grandchildren would. It's best to leave other assets to the children and grandchildren. Better yet, if you can afford it, gift to charity while alive in a tax-efficient way to ultimately save income taxes and reduce your estate later. Two tax-efficient ways to gift to charity are the QCD and the CRUT, or CRUT. A QCD is a qualified charitable distribution from a traditional IRA. It is a great way to avoid taxation on the annual required minimum distribution. To do this, one must be over 70 and a half. The qualifying charity must be paid directly from the IRA account, and there is a $100,000 per year limit. If you are of the age when annual distributions are required to be paid from your IRA, then you can direct all or part of your RMD to go to a qualifying charity. The amount paid directly to charity will not be taxable, which is very nice. A CRUT is a charitable remainder unit trust. This is a way to transfer assets into a trust that will not pay taxes during your lifetime. This type of trust is set up to pay you and someone else, if you choose, a set percentage of its value every year. The lifetime beneficiaries do pay income tax on the trust distributions to them, and at the end of the trust term, the trust is distributed to your chosen charity. Depending upon your tax situation, it is even possible to get a charitable income tax deduction in the year you fund the trust. The QCD and the CRUT are more popular, but there are other ways to give to charity and save taxes. Our goal today was to provide an overview of the more common estate and tax planning tools for today's probate and taxation environment.
Thank you for watching the recording of the webinar. If you have questions, you can reach out to Bonnie or Michael. Here's their contact information, phone, and email. And we appreciate you watching. Thank you.